The following narrative is based on an actual Illinois appellate court case entitled Summers and Novosad v. Nyers. The dialogue and some personal details have been dramatized for storytelling purposes. Lauren Summers and Alana Novosad thought they had done everything right. For 4 years, they had been model tenants in their upscale Cedar Street condominium in Chicago, Illinois. Dutifully, they paid their rent, and to the best of their understanding, they took care of their home. When the time came to move out in June of 2021, they expected a smooth return of their $2,950, that's $2,950, as and for their security deposit. Instead, they found themselves in what will become a landmark legal battle over tenants' rights, security deposits, and little-known legal concept called accord and satisfaction. What started as a routine end-of-lease checkout quickly spiraled into conflict when their landlord, Joseph Nyer, sent an email claiming extensive damage to the property. According to the court records, Nyer alleged damages to the walls and wooden floors that would cost approximately $3,900 to repair, which obviously exceeded the security deposit amount. You can imagine Lauren testifying to something like, "When I opened the email, my heart sank. We had been so careful with the place. The idea that we would not only not get our security deposit back, but would owe more money was shocking." After a tense phone conversation, the parties reached a compromise. Nyer would return about $1,070 of the original security deposit to the tenants, and the tenants would not owe any additional money. This agreement was documented on July 28th of 2021 via email, where Nyer is alleged to have stated, "Confirmation response via email will constitute acceptance of the terms and release of each party of any and all associated claims." Both tenants appeared to have replied with brief messages of agreement, and the matter seemed to be settled. Months later, after consulting with an attorney, the tenants discovered something significant. Chicago's residential landlord and tenant ordinance required landlords to pay annual interest on security deposits and provide detailed documentation for any deductions. According to the Chicago Municipal Code, landlords must hold security deposits in separate, interest-bearing accounts and return those deposits within 45 days after the tenant vacates. The penalties? Well, as you can imagine, they're pretty steep, up to twice the amount of the security deposit for violations, and there's a possibility that the tenant might get attorney's fees. Believing their rights have been violated, Summers and Novosad filed suit against Nyer in July of 2022, seeking $5,900 in damages, which represented twice their security deposit, and as we already discussed, their attorney's fees. Their key argument is, while they had agreed to the compromise on the security deposit amount, they never specifically agreed to waive their RLTO, or Residential Landlord Tenant Ordinance claims, which they weren't aware of at the time. Nyer's defense was straightforward. The accord and satisfaction covered any and all associated claims related to the security deposit, including potential RLTO violations. He argued that the email exchange constituted a binding contract that released both parties from further liability. The case worked its way through the Cook County Circuit Court system, with judges Eileen Bahardi and Scott Norris presiding. The central question: could tenants unwittingly waive their rights to statutory damages under the RLTO through a general release of claims when they didn't know that those rights even existed in the first place? Legal experts watched closely, The RLTO, enacted in 1986, is considered one of the strongest tenant protection laws in the country. It was specifically designed to address the power imbalance between landlords and tenants and prevent mishandling of security deposits, because back in the day, that used to be a really big problem. And to some extent, it might still be, depending on which side of the aisle that you're on. On December 20th of 2023, the trial court sided with the landlord, Joseph Nyer, and they ruled that the accord and satisfaction did indeed bar the tenant's RLTO claims. The court determined that the language, any and all associated claims, was broad enough to encompass the statutory violations, even if the tenants were unaware of them when they agreed to the settlement. The Illinois Appellate Court affirmed this decision, with presiding Justice Fitzgerald Smith delivering the judgment. The court distinguished this case from previous rulings where tenants had successfully pursued RLTO claims despite accepting partial security deposit returns, noting that in this case, the tenants had actively negotiated and agreed to the terms explicitly releasing any and all claims. The Summers and Novosad case serves as a cautionary tale for tenants everywhere, where the RLTO provides significant tenant protections. The court's decision reinforces several key principles. An accord and satisfaction can bar future statutory claims, even if the parties were unaware of those claims at the time that they brought them. Courts will generally enforce the terms of a settlement agreement if it appears that both parties negotiated in good faith. The legal maxim that ignorance of the law is no excuse applies even to consumer protection contexts. This case highlights the importance of knowing your rights before negotiating with landlords. Chicago's RLTO, or Realto for short, provides significant protections for tenants, but those protections can be waived through careless settlement agreements. The most important thing that tenants should take away from a case like this is to consult with an attorney before accepting any compromise on a security deposit. It may seem like a reasonable compromise to deal with your landlord directly. However, ignorance of the law might lead to some of you giving up substantial rights and remedies. For landlords, this case reinforces the importance of clear documentation and explicit language in settlement agreements. Specific references to statutory claims can also help prevent future disputes. Today, Lauren Summers and Alana Novosad have probably moved on to new homes, but their legal battle has become an important reference point in landlord-tenant law. Their experience serves as a reminder that in the complex world of rental agreements and security deposits, knowledge is truly power. For Chicago's approximately 1.5 million renters and tenants, the message is clear. Before you sign anything or accept a partial security deposit, understand your rights. That knowledge could be worth thousands, if not tens of thousands of dollars. And if you like these legal stories in your pocket, like and subscribe.